Right now, people are getting more and more of their information on the internet. You're getting newspapers and television, and blogs and radio. Americans are getting all of it online. And it plays a central role in our democracy by allowing anyone with a computer connected to the internet to publish their ideas, their thoughts, their opinions, and reach a worldwide audience of hundreds of millions of people in seconds. This is free speech. And this is essential to our democracy and to democracy. We saw this in Iran not long ago. Now, Judge, you're familiar with the Supreme Court's 2005 Brand X decision, are you?
I am.
Okay. Well, then you know that Brand X deregulated internet access services, allowing service providers to act as gatekeepers to the internet, even though the internet was originally government funded and built on the notion of common carriage and openness. In fact, we've already seen examples of these companies blocking access to the web and discriminating on certain uses of the internet. This trend threatens to undermine the greatest engine of free speech and commerce since the printing press. Let's say you're living in Duluth, Minnesota, and you only have one internet service provider. It's a big mega corporation, and not only are they the only internet service provider, but they're also a content provider. They own newspapers, they own TV networks, or network. They have a movie studio. They decide to speed up their own content and slow down other content. The Brand X decision by the Supreme Court allows them to do this. And this isn't just Duluth, it's Moorhead, Minnesota, it's Rochester, Minnesota, it's Youngstown, Ohio, it's Denver, it's San Francisco, and yes, it's New York. This is frightening. Frightening to me and to millions of my constituents, or lots of my constituents. Internet connections use public resources, the public airways, public rights of way. Doesn't the American public have a compelling First Amendment interest in ensuring that this can't happen and that the internet stays open and accessible? In other words, that the internet stays the internet.
Many describe the telephone as a revolutionary invention, and it did change our country dramatically. So did television. And its regulation of television and the rules that would apply to it were considered by Congress. And those regulations have, because Congress is the policy chooser on how items related to interstate commerce and communications operate. And that issue was reviewed by the courts in the context of the policy choices Congress made. There is no question in my mind as a citizen that the internet has revolutionized communications in the United States. And there's no question that access to that is a question that society is, that our citizens, as well as yourself, are concerned about. But the role of the court is never to make the policy, it's to wait till Congress acts and then determine what Congress has done and its constitutionality in light of that ruling. Brand X, as I understood it, was a question of which government agency would regulate those providers. And the court, looking at Congress's legislation in these two areas, determined that it thought it fit in one box, not the other, one agency instead of another.
Is this Title I and Title II? Or, as I understand it, Title II is subject to a lot of regulation, and Title I isn't.
Exactly, but the question was not so much stronger regulation or not stronger regulation, it was which set of regulations, given Congress's choice, control. Obviously, Congress may think that the regulations the court has in its holding interpreted Congress's intent, and that Congress thinks the court got it wrong. We're talking about statutory interpretation and Congress's ability to alter the court's understanding by amending the statute if it chooses. This is not to say that I minimize the concerns you express. Access to internet, given its importance in everything today, most businesses depend on it, most individuals find their information. The children in my life virtually live on it now. And so its importance implicates a lot of different questions: freedom of speech, freedom with respect to property rights, government regulation. There's just so many issues that get implicated by the internet that what the court can do is not choose the policy. It just has to go by interpreting each statute and trying to figure out what Congress intends.
I understand that, but isn't there a compelling First Amendment right here for people, no matter what Congress does? And I would urge my colleagues to take this up and write legislation that I would like. But isn't there a compelling overriding First Amendment right here for Americans to have access to the internet?
Rights by a court are not looked at as overriding,
Okay.
in the sense that I think a citizen a citizen would think about it. Should this go first, or should a competing right go second? Rights are rights, and what the court looks at is how Congress balanced those rights in a particular situation, and then judges whether that balance is within constitutional boundaries. Calling one more compelling than the other suggests that there's sort of, property interests are less important than First Amendment interests. That's not the comparison a court makes. The comparison court makes starts with what balance does Congress choose first, and then we'll look at that and see if it's constitutional.
Okay, so we got some work to do on this.